Hello and welcome! I am Kathleen Rigodon and I'm together with my group mates Jemica Basmayor and Chona Genobisa, and we are excited to be here today to talk to you about the Commonwealth Act No. 578. In this presentation, we will be exploring the legal basis of teachers as persons in authority. Before we get started, we would like to take a moment to thank Ms. Rowena Canton for the opportunity to speak with you today. We are honored to be able to share our knowledge and insights on this topic, and we hope that you'll find this presentation informative and engaging. Now, let's dive in. As we explore this topic, we'll be looking at the Commonwealth Act 578 and we'll be discussing what is person in authority and teachers as person in authority. I encourage you to take notes, ask questions, and actively engage with the material as we go along. By the end of this presentation, I hope that you'll have a deeper understanding of Commonwealth Act number 578 and feel empowered to apply this knowledge in your own life. So, without further ado, let's get started. Commonwealth Act No. 578 was enacted on June 8, 1940, an act to amend Article 152 of the Revised Penal Code so as to include teachers, professors, and persons charged with the supervision of public or duly recognized private schools, colleges, and universities within the term persons in authority. This confers the status of persons in authority upon supervisor, principals, teachers, and professor of public or private school. This act also provides penalty to any person found guilty of assault upon these teaching personnel's imprisonment ranging from 6 months and 1 day to 6 years and a fine of 500 to 1,000 pesos. To fully explain this law, I will give the floor to Ms. Jemica Basmayor. Ms. Jemica, you can take the floor now.
Thank you, Kat. Good day, everyone. Are you all okay? Enjoying the weather? Me enjoying the weather because I can drink a lot of hot chocolate and coffee. So let's continue our discussion. So Kathleen discussed about the introduction of Commonwealth Act number 578. And now I will explain to you the two sections of this act. So, Section 1, Article 152 of Act numbered 3815, known as the Revised Penal Code, is amended to read as follows. So, Article 152, or person in authority who shall be deemed as such in applying the provisions of the preceding and other articles of this code, and any person directly vested with jurisdiction, whether as an individual or as a member of some court or governmental corporation, board, or commission, shall be deemed a person in authority. So, the sole purpose of the article is to ensure that individuals who hold positions of authority are held to a higher standard of conduct than ordinary citizens. This means that any offense committed against a person in authority is considered more serious than that if it were committed against an ordinary citizen, and it may carry stiffer penalties under the law. So, who are this person in authority? So, it is someone who holds a position of power, authority, or influence over others and is therefore responsible for maintaining order and enforcing the law. Example of this are public workers or any government employees. For example, judges, police, traffic enforcer, presidents, senators, and most importantly, teachers. So let's continue to the other paragraph. In applying the provisions of Articles 148 and 151 of this code, teachers, professors, and persons charged with the supervision of public or duly recognized private schools, colleges, and universities shall be deemed person in authority. Are you familiar with Article 148 and Article 151? So, Article 148 pertains to the crime of direct assault, which is committed when a person uses forces or intimidation against a person in authority. So, for example, when you assault a person in authority, this will be the crime you will be charged. While Article 151 pertains to the crime of resistance and disobedience to a person in authority. So example, you did not follow the commands or instruction of a person in authority, then this is the crime you will be charged. So why teachers or professors are person in authority? So they are considered person in authority because they hold a position of responsibility and influence over their students. They have power to shape the intellectual and moral development of their students. Also maintain discipline and order inside the classrooms. Teachers held a higher standard of conduct. If someone offended or committed harm to a teacher undermines the authority and integrity of the teacher, they will have penalties under the law. So if the teacher commit a harm to the students or in the education system, they will also punished under the law. So that's all about the Section 1 of Commonwealth Act Number 578. Lastly, Section 2. So Section 2, this act shall take effect upon its approval. Enacted without executive approval, June 8, 1940. So Section 2 of the law states that it shall take effect upon its approval, which means that once the law is signed into law, by the appropriate authorities, it immediately takes effect as a legal binding piece of legislation. In the second statement, or the second sentence of the statement, states that the law has passed by the Philippine National Assembly. It became effective on June 8, 1940 without the need for approval by the Governor General or known as now President of the Philippines. This typically happens when the President does not sign the law within the prescribed period of time after it has been submitted to him for approval, which signed later on by former President Manuel Quezon. So that's all about the sections and statements of Commonwealth Act Number 578. Ms. Chona, take the board.
So, hello everyone, I am Chona Genobisa and let's proceed to the persons in authority distinguished from agents of persons in authority. Persons in authority should not be taken to mean as agents of a person in authority. This is because an agent of a person in authority is one who, by direct provision of law, or by election or by appointment by competent authority, is charged with the maintenance of public order and the protection and security of life and property, such as barrio policemen and any person who comes to the aid of persons in authority. As we all know that persons in authority can be the barangay chairman, municipal mayor, municipal councilors, and provincial fiscals. And these individuals are different from agents of the persons in authority. It is because the agents of the persons in authority are the ones being elected or appointed by the persons in authority. And they are charged to maintain public order and to protect the security of life and property. And these individuals, the agents of the persons in authority, comes to aid the persons in authority. The question is, who are these individuals that can be an agent of the persons in authority? They are the policeman, the municipal treasurer, the postmaster, rural policeman, sheriff, and the agent of the BIR. So if instances would happen and a policeman will say that he is a person in authority, then he is absolutely and legally wrong because he is just an agent of the persons in authority. Now let's go to the person in authority is differentiated from public officer. Persons in authority should also be differentiated from public officer. A public officer is any person who, by direct provision of law, popular elections, or appointment by competent authority, shall take part in the performance of public functions in the government of the Philippines, or shall perform in said government public duties as an employee, agent, or subordinate official, or any rank of class. That's from Article 203 of the Revised Penal Code. So, public officer is different from persons of authority since the term public officer is a general term associated to all the individuals serving the Philippine government. In this fact, we can say that any person in government service is a public officer as defined, but they are not necessarily be a person in authority or an agent of a person in authority. Now that we are done defining persons in authority and we are able to differentiate it from public officer and to agents of the persons in authority, let's move on to the original concept of teachers as persons in authority. It is originally conceived that law did not consider teachers as persons in authority. It was held in People versus Mendoza, 59 Philippine 163, that when a high school student slapped his teacher on the cheek while she was engaged in the performance of her duties as a teacher, the crime committed was only a light felony. This offense is punishable by the imprisonment of not more than 30 days instead of assault upon a person in authority, punishable up to 6 years of prison correctional. So, what triggers the lawmakers to pass the Commonwealth Act number 578 is the criminal case number 4851 of Ricardo Mendoza, wherein he was able to slap his teacher Iluminada Tino on the cheek while she is performing her duties as a teacher. In that time, the crime committed was only a light felony rather than assault because teachers in that time is not a person in authority. And light felony has a punishment of only 30 days of imprisonment. What happened then is that when a person being attacked, slapped, or boxed was the teacher and the attacker was the student or pupil, the only aggravating circumstance was the act is committed with grave insult or an utter disregard for the respect which may due the teacher on account of his rank. And this is because by that time there was no mantle of protection accorded to the teachers. From then on, there were several instances of assault and attack against teachers, instructors, professors, and other public and private officials of schools. But with the passage of the Commonwealth Act number 578 on June 8, 1940, which amended Article 152 of the Revised Penal Code, this picture completely changed. With the Commonwealth Act number 578, Professors, teachers, and the persons charged with supervision of educational institutions were raised to the rank of the persons in authority. The intent and spirit of the amendment is very obvious. They are inherently rooted in the very person of the teacher, who is not merely an intellectual referee in the intellectual playfield and in the market of ideas, but a person of dignity and respect.
Thank you, Miss Chona. When a teacher is not deemed a person in authority, there are instances when the teacher, even while inside the school premises, is not covered by the phrase person in authority, especially when the teacher goes out of the classroom to talk to a person on matters not related to the school or his duties. Assault upon a person in authority, nevertheless, does not consist merely in attacking or laying hands on the persons in authority. It also extends to the serious resistance or serious intimidation on the part of the attacker. Batas Pambansa bilang 232 or the Education Act of 1982 on September 11, 1982, Section 11, Part 3. Teachers shall be deemed persons in authority when in the discharge of lawful duties or responsibilities and shall therefore be accorded due respect and protection. Teachers in their security of tenure, some legal basis. It is a settled rule that every employee is entitled to the rights provided in our Constitution and laws. Employees has the following rights: the right to equal work opportunity, right to weekly rest day, right to wage and wage-related benefits, and security of tenure. The phrase security of tenure is a constitution guarantee. The 1987 Philippine Constitution, Article 9B, the Civil Service Commission, Section 2, Subsection 3 states, no officer or employee of the civil service shall be removed or suspended except for cause provided by law. Subsection 6 also provides temporary employees of the government shall be given such protection as may be provided by law. They can be terminated from service only for a valid cause supported by substantial evidence and after due process where they are afforded the opportunity to be heard and to present their defense. A school must show cause in order to dismiss a teacher who has attained tenure status. Some state statutes provide a list of circumstances where a school may dismiss a teacher. These circumstances are similar to those in which a state agency may revoke a teacher's certification. Some causes of dismissal include immoral conduct, incompetence, neglect of duty, substantial noncompliance with school laws, conviction of a crime, insubordination, and fraud or misrepresentation. The essence of security of tenure. Security of tenure is a right of an employee and mandated by law that protects them from being unjustly terminated from the employment of their employers. Termination of employment isn't simply just about removing someone who you do not agree with or you hate. If it is used as such, employers may be perceived as highly oppressive and is high and favorable to the employee. Security of tenure should also be in mind when terminating the employment of an employee. Professor Vicente G. Cinco, in his book Philippine Political Law, has stated, nothing can be more demoralizing to a group of civil servants than the fear that they might be removed from their posts anytime at the pleasure of their superiors. It goes without saying that a demoralized force is an inefficient form. Security of tenure is necessary in order to obtain efficiency in civil service. For this purpose, the Constitution provides that no officer or employee in the civil service shall be removed or suspended except for cause as provided by law. Security of tenure does not only mean that the employee is protected against illegal dismissal, it also guarantees the employees against unwarranted transfers made without their consent. Article 279, Security of Tenure. In cases of regular employment, the employer shall not terminate the services of an employee except for a just cause or when authorized by this title. An employee who is unjustly dismissed from work shall be entitled to reinstatement without loss of seniority rights and other privileges and to his full back wages, inclusive of allowances, and to his other benefits or their monetary equivalent computed from the time his compensation was withheld from him up to the time of his actual reinstatement, as amended by Section 34 Republic Act Number 6715 on March 21, 1989. Thank you for joining us today for this presentation on Commonwealth Act Number 578. We hope you find it informative and engaging. Before we go, we'd like to leave you with a few key takeaways. Commonwealth Act 578, also known as the Revised Administrative Code of the Philippines, defines the scope and extent of the authority of teachers as persons in authority. This means that teachers, as public employees, are granted certain powers and responsibilities to maintain order, discipline, and safety within the educational setting. Under this act, teachers are considered persons in authority while they are performing their official duties or when they are within the school premises. This designation grants them legal protection and allows them to exercise authority to ensure effective teaching and learning environments. As persons in authority, teachers have the power to enforce discipline, maintain order, and protect the welfare of students and staff. They can issue instructions, give commands, and impose reasonable rules and regulations to maintain order and ensure the smooth functioning of the educational institution. Moreover, teachers have the authority to take disciplinary measures within reasonable limits to address disruptive or harmful behavior exhibited by students. This includes the power to reprimand, administer corrective measures, and impose appropriate sanctions as deemed necessary in line with the school's policies. It is important to note that while teachers are granted the status of persons in authority, they are expected to exercise their powers responsibility and within the bounds of the law. This means they should act in a fair, just, and impartial manner, respecting the rights and dignity of students and other individuals within the school community. In cases where teachers need to exercise their authority beyond the school premises, such as during field trips or school related activities, they may still be considered persons in authority as long as they are carrying out their official duties and responsibilities. Overall, Commonwealth Act 578 recognizes teachers as persons in authority within the educational setting, granting them the necessary powers and responsibilities to maintain order, discipline, and the overall welfare of students, ensuring a conducive learning environment. We encourage you to reflect on what you've learned today and to think about how you can apply this knowledge in your own life or work. If you have any questions or comments, please feel free to reach out to us in our messenger accounts. Once again, thank you for your time and attention. We appreciate the opportunity to share our knowledge and insights with you. Have a great day!